Good. So welcome to this session where we are honoured by the presence of Mr. Justice Marshall Rothstein, who is going to talk about advocacy and intellectual property cases in the Supreme Court of Canada, a topic on which he's amply qualified in a number of ways, as I'll mention. Just a brief introduction to Justice Rothstein for those who, for some odd reason, have been unaware of of his accomplishments. He graduated from with a BCom and a law degree from the University of Manitoba for the reason that he comes from Winnipeg. And so off he went to Manitoba and was then, after finishing his qualifications, went to the Manitoba Bar, practiced for a number of years there through to 1992, becoming partner in one of the large firms there, and had extensive practice as a litigator in the various courts in Manitoba, in courts of appeal, including the Federal Court of Appeal and the Supreme Court of Canada, as well as before administrative tribunals. And not only did he practice before administrative tribunals, he was himself operating as an arbitrator and a tribunal himself under the Human Rights Act of both Manitoba and Canada for a number of years as well. He's taken an active interest in education, legal education. He's lectured frequently at the Manitoba Faculty of Law and elsewhere. He's been a regular friend and helper of IP Osgoode. And apart from IP, his interest has been as counsel and as litigator, and his practice was largely in transportation and regulatory and competition law, a set of skills which I think was very important when he came to the Federal Court of Appeal, or Federal Court, as he did in 1992. Actually, when you look at the significant years of Justice Rothstein's career, it was clear that he was going to be destined for a life in IP, even though he didn't know it. He was, for 20 years, a partner before he came to the court in 1982, and 20 years, of course, is the standard patent term. He was at the Federal Court for 7 years before being appointed to the Federal Court of Appeal, where he sat for 7 years. And of course, 7 years is the apprenticeship term that was extant in 1623 when the Statute of Monopolies was passed. And in fact, the Statute of Monopolies was, the term of a patent for us in the Statute of Monopolies was for 14 years. It was designed for the master to let his apprentice, 2 sets of apprentices, learn the trade, and then the thing could come off monopoly. So as you see, Justice Rothstein served his apprenticeship in the court in the trial division of the Federal Court and in the Court of Appeal, and then without any significant legal challenge was appointed to the Supreme Court of Canada in 2006, and in fact was the first judge who went through the parliamentary subcommittee screening. Most people say that he laid the precedent to which many aspired and few have reached. If you go back, I think it's on record, you could go back to that. It's a very entertaining performance before the parliamentary subcommittee, and anybody who voted against him after that must have been a total dolt. In any event, the experience that Justice Rothstein has in intellectual property, I think it's fair to say, comes mainly from his work in the court. He didn't come across much intellectual property, dare I say it, in Manitoba. But when he went to the Federal Court of course, that is one of the staples of the Federal Court and Court of Appeal. And he quickly got very interested in these cases, and I think when he was appointed to the Supreme Court of Canada, one of the important aspects that the government looked at when suggesting his name and putting his name forward was his significant intellectual property expertise that he'd gained as a trial judge and Court of Appeal judge. And he has continued in that vein, as you know, since 2006. He has been, I think, largely the judge who has written the most and the most influentially in patent and trademark and copyright cases since then. The interesting thing, of course, is that when you actually look at the record of cases since he's been appointed in 2006, the patents and the trademark cases were decided unanimously, but the copyright cases, well, they're a pretty lot, aren't they? The unanimity seems pretty hard to get in a copyright case, and if one looks at the 6 cases that were decided last year, I think a record 6 cases in copyright that were taken by the Supreme Court for decision, only 3 were unanimous, and one of them not quite either. It was sort of 8-1 with a sort of a concurrence with a sort of concurrence dissent, a dissent on administrative on the administrative aspects of it, standard of review stuff, which judges always seem to dissent on. But we remember that Euro Excellence case, 4-3-2 decision, 5-4 decisions in the entertainment software case last year. Similarly, in the Access copyright case, both dissents written by Justice Rothstein for a 4-person minority, and with Justice Rothstein also writing a unanimous opinion, or virtually unanimous opinion there as well, and a majority opinion as well. So I'm not sure what it is about, whether it's about something to do with copyright or something to do with Justice Rothstein so when it comes to copyright. I think it's something to do with the subject matter, because those cases, when you start looking back at them going right back to the even 1940s, the cases where in IP where there's been the most dissent have been copyright cases. Case perhaps of the technology hitting an ancient statute and and causing the judges a great deal of difficulty in trying to accommodate the statute to the technology or vice versa. The alternative and possibility, of course, is that we have such wonderful advocacy before the Supreme Court of Canada by advocates on both sides that it truly causes the judges so much head scratching that none of them are able to agree on the result. And I do have to say, when I was at a colloquium last week at that other law school at University on University Avenue, the patent bar there was busy preening itself on its accomplishments. So I'm sure they would have an explanation of why in copyright cases there was such a lot of dissent. The quality of the argument was such that no one could ever make up their mind on the court. It would be their explanation, possibly. But the reason we have Justice Rothstein here is to perhaps give us the true reason for this. Whether it's attributable to the advocacy is something that I'm sure we'd like to, we will hear shortly. So without more ado, I invite Justice Rothstein to come and present his talk.
Good afternoon. Can I be heard? Well, first of all, David, thank you very much for a generous introduction. Your story about the history of the expiry of patents in 7 and 14 years makes me think that maybe I've outstayed my welcome already. But I'm going to carry on for a while. You're querying why there's so much dissent or disagreement in copyright cases, and that's because the judges, of course, all write their judgments, and because they're writers, they figure they're all experts in copyright. So everybody's got something to say. But I do appreciate your kind sentiments, and I do have to tell you, though, that David's sentiments are not universally held. Email, Sheila Rothstein to Justice Rothstein, 10:53 a.m. I told you to remove all the linen, including the blanket cover. You did not listen to my instructions and only did half a job. I hope you do your legal opinions better than removal of linen from a bed. When you get home, you'll make the bed all by yourself. I've abbreviated that. That's not the whole email, but David told me not to recycle, so I thought I'd better just stop there. But all I can say is that I'm sure glad that Sheila wasn't the one introducing me today. But judges are usually treated with a good deal of respect, whether we deserve it or not, but not by everyone. Recently, Sheila and I had been away. When we came home, she told me she wasn't going to unpack until the next day. So I put my dirty laundry in the washing machine and turned it on. The next day in the office, I received the following email. Sheila Rothstein to Justice Rothstein, 9:20 a.m. You're absolutely forbidden to use the washing machine. You overloaded the wash and there's soap on every piece of clothing. I have to redo it all. It's time for you to concentrate on your work at the office instead of creating havoc at home. Today my topic is advocacy in intellectual property litigation in the Supreme Court. Well, there's two crucial stages at the Supreme Court: getting leave to appeal and winning the appeal. How important the leave application is? If you don't get through the gate, you don't get to the trough. It doesn't matter how good your appeal is or if you could have won the appeal if you don't get leave. So I'm going to start with our leave granting process and give you an idea of how these decisions are made. First of all, a few statistics. We receive an average of about 550 applications for leave to appeal every year. Over the last 10 years, our grant rate has been between 10 and 15%, although we don't have a target and we don't grant or deny based upon the numbers. Last year, we granted 65 leave applications, and we had 15 additional criminal cases that come to us as of right. So the total appeals we heard, or that we either agreed to hear or were required to hear, was 80, and that's about the average number that we hear each year. On average, about 3% of the leave applications involve intellectual property cases. So that translates to about 15 or 16 applications each year. And again, on average, about 3% of the appeals we decide would be in intellectual property cases. Just for context, I'll tell you that when it comes to applications granted, about 50% of the leave applications granted last year involved criminal law, including 10% of those with constitutional overtones. In the non-criminal 50%, about 2/3 of the cases would be in the public law area, like judicial review, and only 1/3 in the private law area. So if you consider intellectual property in the private law area, of the roughly 15 appeals in the private law area, perhaps 2 or 3 might involve intellectual property. But again, these are averages only. Our criteria for granting leave is set out in Section 40 of the Supreme Court Act, and I'll quote it briefly. where the Supreme Court is of the opinion that any question involved therein is by reason of public importance or the importance of any issue of law or any issue of mixed law and fact involved in that question, one that ought to be decided by the Supreme Court, or is for any other reason of such nature or significance as to warrant a decision by it. So basically, we have virtually unfettered discretion to grant leave. But in practice, we're looking for legal issues of wider significance than just resolving the issue between the parties. When the issue is one of public importance and we think it calls for a decision from our court, we'll grant leave. We say we're not an error-correcting court, but a jurisprudential court. Sounds rather pretentious, but that's all it means. If we deny leave, it could be for any number of reasons. But it's important to note the denial of a leave application has no precedential value. It doesn't mean we thought the Court of Appeal was right. The Court of Appeal decision stands as a precedent, but it is of no value to say that the Supreme Court denied leave to appeal. Even if we think the Court of Appeal got it right, we may grant leave if we think the leave application raises an issue of public importance. I'm going to give you a couple of examples of circumstances that have led to our court granting leave that are relevant to the field of intellectual property. First of all, where the statute or common law has to be applied to new technology. And David referred to the copyright pentology of last year. Entertainment software versus SOCAN. The issue was whether the communication right in Section 3(1)(f) of the Copyright Act was implicated when a video game was downloaded that contained the copyright owner's work. In SOCAN v. Bell, the issue was whether listening to online previews of musical works by consumers before purchasing the work constituted research for the purposes of fair dealing. So these cases are examples of the application of copyright to new technology. 2, where there is an issue of widespread public interest and importance. For example, access copyright. Well, the issue was teachers copying material from textbooks and others for students, and whether that fell within fair dealing rights and whether such dealing was fair. Well, it's just a case of photocopying and just an application of the criteria for fair dealing outlined in the CCH case. However, there were huge numbers of provinces, school districts, authors and publishers associations and others who had been parties in the lower courts and who had become parties at the Supreme Court, and it was obviously a case of widespread public interest and importance, even though it didn't particularly involve a question of new technology. And one wonders now whether the photocopying itself might be so out of date that there may be less significance to the case than was thought at the time. But in any event, I'm going to give you a couple of examples of where we won't grant leave. First of all, if the case is factual, or if there might be a legal point but the facts are so convoluted that we'll only be rendering, we think, a factual decision, or we'll make a decision that's so peculiar to the facts that it won't be generally useful as a precedent. Sometimes in drug patent cases, the issue on the leave application will boil down to whether the patent holder's expert evidence or the generic's expert evidence should be accepted, and that won't open the gate. 2, where the leave application is from an interlocutory decision. In those cases, we often think we should await a final decision before granting leave because the issue may be procedural or the record may be deficient. We've had a number of leave applications pertaining to Section 8 of the Patent Medicines Notice of Compliance Regulations. And you'll know that Section 8 of the regulations provides that when a patent holder applies for and obtains an order prohibiting the Minister of Health from issuing a notice of compliance to a generic manufacturer, preventing it from marketing its drug product, and the prohibition application is subsequently dismissed by the court or the Court of Appeal, the generic may be entitled to damages from the date of the notice that the notice of compliance would have otherwise issued to the date the prohibition application was denied. The problem with these cases is that the applications for leave have all been from interlocutory decisions of the federal court. So there have been no leave applications where there has been an actual finding of damages by the federal court. I understand there are at least one case now where there has been such a finding, but no leave application so far from a completed case. On these interlocutory applications, the applicant for leave, even though it was only interlocutory, wanted us to determine the scope of damages, whether they should include future lost profits, disgorgement of the patent holder's profits, punitive damages, loss of market share, and the like. I can't say that we would never grant leave from an interlocutory decision. Sometimes we do, but we haven't in the case of Section 8. I'll take a few minutes to describe our process. When a leave application is filed and all the materials are in, a staff lawyer at the court prepares a memo summarizing the materials submitted on the application. Chief Justice appoints 3 panels of 3 judges each to decide the leave applications. The composition is changed annually. Each judge receives an average of about 3 or 4 leave applications each week. We receive the staff lawyer's memo and all the leave materials. Speaking for myself, I can decide about 2/3 of the applications on the basis of the staff lawyer's memo. This would include the self-represented applications, which usually don't take much time to analyze. In the other third, which will include the intellectual property applications, in my case, I read the trial and appeal judgments and the leave memorandums. Sometimes I call the staff lawyer who wrote the memo to discuss the application if I think I require further clarification. The 3 judges circulate their decisions on the leave applications to each other. Where the panel has unanimously agreed to grant leave or deny leave, a memo is sent to all the other judges. It's called an unless memo. Staff lawyer's memo is attached. The unless memo says that unless any other judge objects to the decision to grant or deny leave, the decision will be made public on a certain date. I'd say that in a year there'd be very few cases that would generate a question from any other judge. If there's a split within the 3-judge panel on whether to grant leave, all of the judges discuss this at our monthly court conference. The numbers can vary, but I would estimate that there are probably 4 or 5 in this category each month. We have what we call a rule of 4. If 4 judges want to grant leave, leave will be granted. I set a rule of 4, but strictly speaking, it would be more accurate to call it a convention, because under our Supreme Court Act, it is the leave panel of the 3 judges who are assigned the application who have the jurisdiction to grant or deny leave. But if 4 judges at the court conference would like to grant leave, the panel of 3 judges will virtually always agree. Almost all leave applications are decided on the written material. I say almost all because we have the power to grant a party's request for an oral hearing or to call for an oral hearing at our own motion if we think it's necessary. During the course of a year, I would say we don't have more than 3 or 4 oral leave hearings. We do this when we may be unsure of the issue from the written material, or we may think there is an issue we would like to consider, but from the material filed, we don't have confidence that the applicant is focused on the issue that we think is important. We granted an oral leave application, we granted an oral leave hearing in the application of Eli Lilly versus Nova Farm in the spring of this year. The application involved Lilly's drug Plavix, drug used in the treatment of schizophrenia. Lilly had lost in the federal court and federal court of appeal on the grounds of lack of utility, a requirement, as you know, in the definition of invention in Section 2 of the Patent Act. Lilly's point was that the federal court of appeal had wrongly adopted a new and more stringent test for utility of a patented invention. Lilly argued that the traditional test is that a mere scintilla of utility would suffice to meet the usefulness requirement for a patentable invention. Lilly said that the Federal Court of Appeal had adopted a promise of the patent test, whereby if the specification in the patent purports to promise greater utility, then the patentee is required to demonstrate that the promise of greater utility has been fulfilled, even if the promise required more than a scintilla of utility. The Federal Court and Federal Court of Appeal found the Plavix patent to be invalid for lack of utility. Lilly provided two very impressive affidavits in support of its leave application. One from Sir Robin Jacob, recently retired from the United Kingdom Court of Appeal, and the other from Paul Michel, recently retired as Chief Judge of the U.S. Court of Appeals for the Federal Circuit. The burden of those affidavits was that Canada's promise of the patent test was out of step with the law in both the United Kingdom and the United States. This is one of those rare cases where we did decide to hold an oral leave application to get further visibility on whether we should grant leave. The hearing was in May of this year. We were in doubt about whether the promise of the patent issue and Canada being out of step with the United Kingdom and the United States was argued and dealt with in the Federal Court and Federal Court of Appeal. At the oral hearing, it became apparent that to whatever extent the issue was argued, those courts did not consider it sufficiently significant to comment on it. Our preferred approach at the Supreme Court is to review findings of the Court of Appeal or a trial court. It is not to make ab initio findings on a legal issue. Indeed, as a general rule, an appeal court should not entertain a new issue on appeal unless, in the interests of justice, it is required, or and that there is a sufficient evidentiary record and findings of fact to do so. Well, while, as I said, the affidavits of Sir Robin Jacob and Paul Michel were impressive, they were not evidence in the federal court, and there had been no opportunity to cross-examine by Novafarm. There was also another issue, but not one that Lilly relied upon. It actually was raised by our leave panel. Back in 2002, the Supreme Court decided the AZT case, Apotex versus Wellcome. The case dealt with sound prediction as a basis for proving the utility of an invention. In AZT, the court said that to prove utility, an invention must be soundly predicted at the time of the patent application. Of course, at that date, the invention would not have been marketed, so there would be no evidence of market acceptance. However, in the Viagra case, decided just last year, our court said that evidence of utility may be found in the reception of the invention by the public. Well, there's no doubt that Plavix has been very successfully received in the market, which makes it somewhat anomalous that a court should find that Lilly's invention of Plavix lacks utility. So there's an argument to be made that if the AZT case is to be interpreted as precluding the evidence of market acceptance to prove sound prediction, perhaps it is worth looking at. However, that wasn't Lilly's argument on leave. So the promise of the patent in Canada being out of step with the United Kingdom and the United States on the test for utility had not been dealt with, or at least dealt with in their reasons by the lower courts, and the admissibility of evidence of market acceptance or utility, in fact, it is known in the United States, of a product for purposes of proving sound prediction and utility also had not been dealt with or argued by Lilly. And the interests of justice exception didn't apply. For these reasons, our panel decided to deny leave in the Lilly case. Bottom line is that where an issue is raised before our court for the first time and isn't dealt with by the courts below, it will only be in exceptional cases that our court would grant leave to appeal. And the Lilly case was not such a case. Well, I've explained why we didn't grant leave in the Lilly case, but formally we don't give reasons for granting or denying leave. And once leave is granted, the decision is never revisited. Sometimes when we're preparing for the appeal, or when we hear the appeal, we conclude that it was a mistake to have granted leave. Perhaps the case is very fact-intensive, or the record is not clear enough to give us confidence about the legal decision that has to be made. Then we just have to live with our decision and do the best we can. I'll turn to the appeal stage once leave has been granted. And I'll start with the mechanics. Before each case, we read the factums and the trial and appellate court judgments. Before the hearing, we'll likely have developed a preliminary view of whether the appellant or respondent has the better case. In fact, in the last month or so, we've adopted a new practice of meeting about 15 minutes before the appeal hearing and having a short discussion of the case so that each judge kind of expresses a general idea of where he or she thinks they might be in terms of the issues or of the result in the case. So that means that the factum is of critical importance. One of the things that was done by counsel in a tax case recently was to put a page in right at the beginning of the factum setting out a glossary of terms and acronyms. And that was extremely useful. There's a lot of jargon in tax law and in intellectual property law. A lot of words and phrases have a unique meaning and application in the intellectual property context. Anticipation, obviousness, utility, confusion, fair dealing. You can't assume all the judges will have these types of terms and their intellectual property meanings at their fingertips. So it's always prudent to take a page of the factum to set these out with their meanings or a brief interpretation in the authorities or academic writing. Normally, you just put the acronym or the reference to the word in the narrative of the factum and explain what it is early on, and sometimes not explain, assuming the judges would understand. But even if you do explain early on, I'll be reading a factum. When I get to page 25, I'm going to have to go searching back for the definition or the meaning of the acronym earlier in the factum, not knowing exactly where it is, and this can be a little frustrating and inefficient. But if you put in a single page with a glossary of terms and acronyms, the judge can flag it and go there immediately when he comes upon that term or acronym in the reading of the factum. So it's a very effective thing to do. And even better, I say, duplicate the page and have a loose copy so that the judge can keep it right in view when reading the factum and easily refer to it as a technical word or acronym comes up in reading through the factum. I have a rule. Adjectives and adverbs get you into trouble. So I want to say something about rhetoric. I'm going to refer to both factums and memorandums on leave applications to make the point. Especially in the drug patent cases, we see hyperbole, sometimes mischaracterization of the trial or appeal court judgments, exaggeration, or perhaps a disrespectful characterization of the lower court judgment. Here are a few examples. I've selected from both patent holders' factums and generics factums. I quote, "Flawed theory of statutory interpretation applied by the Federal Court of Appeal." End of quote. All you really need to say is, unsupported by the authorities. It makes the same point, and it's respectful of the lower court. Quote, "In a further attempt to justify its unorthodox approach, the Federal Court of Appeal relied on." End of quote. Well, such terminology imputes motives to the lower court. That doesn't get you anywhere in our court. Quote, "By this approach, the FCA fully abdicated its duty of interpretation." Close quote. That's not a respectful way to refer to what the lower court did or didn't do. Quote, "It's a matter of public importance that the Supreme Court reject any attempt by the lower courts to avoid the constitutional duty incumbent on them to interpret for themselves the process of statutory interpretation." Pretentious, if nothing else. But the suggestion here is of a misfeasance by the lower courts. You know, judges are skeptics by nature. A disrespectful characterization of the lower court decision generates skepticism about whether there really is an error in that decision. Quote, "The decision below disrespects the balance Parliament sought to achieve, heavily tilting it in favor of multinational companies at the expense of all Canadians." Close quote. It's a case about money between patent holders and generic companies. Multinational companies apparently against tiny, weak Canadian generic companies. We didn't just jump off the turnip truck. Quote, "Claims by generic companies for hundreds of millions of dollars stand to be affected, and the decision below will dramatically increase the amount Canadians needlessly spend on brand name drugs. The importance of the appeal cannot be overstated. The regulations created a framework which directly affects the health and welfare of all Canadians." Close quote. Well, trying to align a client's position with that of the public interest can be effective, but you can't overstate the case. John Laskin, you will know is a highly respected judge of the Ontario Court of Appeal, told me a story about sitting with Coulter Osborne, a former Associate Chief Justice of Ontario. He says he was on a panel with Coulter where each side was arguing that they had the moral high ground in the case. But the panel didn't think much of either side's position. Osborne started his oral judgment out with the observation, "In this case, the moral high ground is largely unoccupied." Well, parties in the drug patent cases have to remember that they may be in a street fight between themselves. But in an appeal court, rhetoric doesn't carry any weight. A moderate approach using moderate language is far more persuasive. Respect for the court appealed from is essential. Appeal courts and the Supreme Court try to be very respectful, especially when they have to disagree with the court that wrote the judgment that has been appealed to them. You shouldn't see this type of language in court judgments, and it shouldn't be in factums either. Of course, you get carried away. We all get carried away and really want to make our case the strongest way we can, and we feel quite emotional about how wrong the other side is. But you gotta keep your feet on the ground, and you can't get carried away when writing your factum. When you write your factum, your objective is to give the court a template for the judgment it writes. You have to write the factum as if it is the judgment. If you scrap the hyperbole and exaggeration, and especially the mischaracterization and disrespect, judges won't miss the point, and you'll receive a much more favorable hearing. I'm going to make one more point about factum writing, and it's a general point, but it applies to intellectual property cases especially. Point first, writing. I first heard this from John Laskin. You shouldn't write a factum like a mystery novel, setting out the plot and the dialogue and wait until the end for the reader to discover the point you're trying to make. You have to set it out at the beginning what point you intend to make. It has to be clear and simple. And it's because people read by instantaneous prediction and confirmation. Point first writing provides prediction, which is then confirmed by the details that follow. It's especially important in complex and technical appeals where it's easy for a non-expert, the judge, to get lost. So you keep the judges in familiar territory by telling them what to expect at the beginning and then developing it. If the explanation you're giving is long, and you should probably briefly restate the point you're trying to make to keep the judges with you as they are reading. It's especially the case in intellectual property law at the Supreme Court, where most judges won't have the experience or expertise in the area. So it's unlike criminal law or admin law, which would be most of the Supreme Court cases, and with which many of the judges will have familiarity and expertise. You got to remember, when you're presenting your case in writing and at the oral stage, you're teaching the judges. I always say that you should remember the best teachers you had in law school or undergrad or even high school. They were the ones that could explain things in a way that made it easy for you to understand. You should follow the same practice. You should also remember that the 40-page limit on factums is a maximum and not a minimum. The shorter the factum, the better. It means you have focused on the issue, narrowed them, explained them as simply as possible. You don't get more marks for longer factums. Now a word about the oral hearing. When I was at the Federal Court of Appeal, counsel had an hour and a half to make their argument. There were only 3 judges, so it was possible for each judge to ask the questions they wanted to ask. I would estimate that in 25 to a third of the cases, I might have changed my mind from what I had thought from reading the factums, or at least changed the basis of the decision if I didn't change my mind. At the Supreme Court, you only have 1 hour to argue, and 9 judges are asking questions. So the time is shorter, and each judge has to limit the number of questions he or she asks so as not to preclude the other judges from asking their questions. So our preparation in the Supreme Court has to be more thorough prior to the oral hearing. And therefore, the factum is even more important than at the Federal Court of Appeal. The judges are probably more inclined to form a firmer view of the decision that they think has to be made from the reading of the factums. I want to say a word about questions. I think I can speak for most of the judges when I say that while we may ask a question during the hearing for information generally, usually we're querying the position on at least the specific point that is troubling us, even if it doesn't go to the final disposition of the appeal. Either counsel is able to answer the question, evades answering, or fails to explain why our question isn't relevant. The best and most helpful counsel are those who directly answer our questions. It's the opportunity to have this back and forth with questions and answers that helps to either firm up our view or cause us to change our mind. In my view, normally, counsel should prepare their oral argument to be given in half an hour. After all, we've read the factum, it just doesn't have to be repeated. And they should save the other half for answering questions. Sometimes we hear counsel who thinks that he or she has so much to tell us that when they're asked a question and they see their time is being used up, they start to talk fast. That's useless. Speaking for myself, I'm trying to understand and consider what counsel is saying. If they just talk fast, I can't do that, and the oral argument is just a blur. I say that if you are prepared to speak for half an hour and you're asked questions for the other half, that's optimal. If you're not asked questions, it's either because the judges agree with you or they think your case is so bereft of any possibility of success that it's a waste of time to ask questions. Either way, if you sit down after half an hour, the judges will consider it an act of mercy. Now a word about interveners. Organizations and companies that have an interest in an appeal frequently intervene. We don't allow interventions at the leave stage, only once leave is granted. Interveners are not to comment on the facts or the merits as between the parties. We expect them to have an interest in one or more of the legal issues being argued because of their wider impact in the future. An intervener is limited to a 10-page factum and 10 minutes of oral argument. What that does is require the intervener to focus on one or perhaps 2 points only. Once I have an idea of what the appeal is about, I often read the intervener factums first because they're short and concentrate on 1 or 2 points of wider public interest. So intervener factums are very important. I'm going to give you one example. About 3 or 4 years ago, we heard a trademark appeal involving alleged confusion in the use of the term masterpiece by 2 companies in the retirement residence industry. There were a number of issues in the appeal. One was whether the geographical location where the trademark is used or proposed to be used affects the likelihood of confusion. One of the parties had been operating in Alberta, the other in Ontario. The Federal Court of Appeal had distinguished a number of authorities which might have been seen as an acceptance that geographical locale in which the marks were used or proposed to be used is relevant in determining the likelihood of confusion. Well, the International Trademarks Association, represented by Daniel Bereskin, intervened to stress solely that the trademark regime in Canada is national in scope and that the owner of a registered trademark is entitled to exclusive use of that mark in association with its wares or services throughout Canada. The factum of the association was clear, sequential, and confined to that 1 point only. Well, the half-dozen paragraphs in the judgment on that point is a pretty close paraphrase of the paragraphs in the factum of the association. That's what a judge is looking for. I told you that you have to write your factum as if you're writing the judgment, and that's the way this factum was written. And it gives the judges confidence in the analysis and helps them in writing their judgment. And in the masterpiece case, the intervention of that association did that job. After hearing the oral argument on an appeal, we convene in a court conference, and each judge expresses his or her view on the different points raised in the appeal. Normally, each judge has a position, and after some discussion, the Chief Justice will poll the judges to see whether we're unanimous, or if not, who is on the majority side. She'll then ask for volunteers to write the judgment. There aren't usually many volunteers in patent cases. However, in copyright cases, everyone volunteers. As I told you, that's because all the judges think they're experts in copyright. Perhaps it's because, in fairness, perhaps it's because of the tension, public tension between the rights of authors and copyright owners and that of users that generates the judge's interest. And perhaps it's just the fact that these are high-profile cases that get a lot of publicity. Judges are human, after all. Well, you might think the same is true in the drug patent cases as well, but I suspect that those cases are thought to be more technical and remote. In any event, the writing judge will take account of the views expressed at the court conference and try to have regard for them in the course of writing, and of course those views have to be compatible with the views of the judge who is writing. And when the reasons are drafted, they're circulated, comments are received from the other judges. Where judges disagree, they'll indicate that a dissent or concurring judgment will be written, And when that judgment is circulated, the judge who wrote the majority will have to adjust his or her reasons to accommodate and respond to some of the things said in the dissent or concurrence. Well, those are a few of the things I can tell you about advocacy in the Supreme Court and some things about intellectual property advocacy from my 7.5 years at the court. I have just 2 years to go until I get the mandatory retirement hook. And as I'm approaching that milestone, the discussion of retirement from the court and what happens after I leave is raised periodically by friends and colleagues. That hasn't gone unnoticed by Sheila. Email Sheila Rothstein to Justice Rothstein. You have 1.5 to 2 years left to work on the court. I want to buy a condo in Florida, East Coast. You are ignoring the fact that we need a second home. The price of condos is not going down, and the Dow is at an all-time high. We have to go down to Florida in the next few months to look and buy. Get your head out of the sand and face reality. In 2 years, you're toast on the court. I'm not moving back to Winterpeg or out of Ontario, where I have my medical license. Wake up. Well, as you can see, my mandatory retirement from the court is really causing Sheila some anxiety. One more email. Sheila Rothstein to Justice Rothstein. You only have 2 years left of the court. What are you going to do when you leave? Email Justice Rothstein to Sheila Rothstein. I haven't given it much thought yet. Email Sheila Rothstein to Justice Rothstein. Too complacent. Put out some feelers. You have to get a job when you leave the court. Get off your ass and find a job. If any of you know of any opportunity, thank you for inviting me and thanks for your attention. That's fine.
Well, thank you very much for that, Justice Rothstein. I suspect that you're grateful that Sheila Rothstein took a career in medicine rather than law. She would be a formidable advocate at the Supreme Court, probably disregarding almost all the rules that you laid down for effective advocacy,
Right.
especially the bit about respect to the courts. We have time. We've allotted quite a lot of time to today, if necessary, to take questions, because it's a unique opportunity to have a sitting Supreme Court judge here to talk about how you should fare, what you should do to convince him or her of your position. Oh, sorry, thank you. So Justice Rothstein will be happy to take questions. He'll be happy to take them. He may not be happy to answer them. And we'll if you try and confine your question to the relevant to the topic which is before us. Remember that Justice Rothstein is in a position where if you're going to say, what do you think of this or that case, and it's likely to be before the court again, you're not going to get much of an answer from him for obvious reasons. But I think with that constraint, are there any questions or comments?
You may have confined them too much, David.
I think I should have confined them. Otherwise, there were maybe some Sheila Rothstein proxies out there. Any queries or comments that you want to make? Which case we would. Yeah. Perhaps I should.
I can speak loudly as well. It's all being recorded. Oh, okay. I just wanted to ask, maybe in a general sense, you talked about how the factums and everything will influence your decisions. Will the justices themselves influence each other's decisions? Will you have kind of a back and forth with the other justices in any degree? And does that have a significant influence sometimes?
Sure. What'll happen is that different judges get to be known for their familiarity and sometimes expertise in different areas, in intellectual property or in criminal law or that kind of thing. And so individual judges will very often contact one of the other judges in the particular field that the case is about and say, well, what about, what do you think? And especially in the intellectual property area, I can tell you that not that I don't consider myself an expert. I have familiarity, but I don't consider myself an expert like David. But judges will come to me and say, well, what does this mean? And why are they saying this in the factum and so forth? So yeah, the judges do interact in that way before the case once they've read the factums. Once the judges at the court conference, normally the judges are fairly firm. Once they hear the case orally and they come to the court conference, they express their opinion. They normally will stay with that opinion right through to the end. I say normally because in some percentage, 10% or 20%, judges might change their mind once they read the reasons that are being written. And occasionally a judge writing may find that it doesn't write, and they end up going the other way. So that kind of thing can happen, but it's not usual. So the interaction between the judges is usually beforehand. Now, afterwards, when you're writing, as I said near the end of my remarks, you're going to get comments from all the other judges, making various suggestions about changes that they would like to see you make. And you may have to respond to a dissent or a concurrence. So you're going to have interaction in that way, but the interaction I think you were asking about was the interaction that takes place before the case, and that certainly takes place.
Thank you.
My question also relates to expertise. You mentioned you have familiarity with IP, but not necessarily an expertise. I'm wondering how much initiative do judges take on their own to maybe go and learn a bit outside of their familiarity zone, or how much does it depend on counsel? And I'm thinking specifically about using secondary literature or resources that we often see quoted in judgments.
Well, I would say that the answer is that almost exclusively it depends upon counsel, and it's for this reason, that the secondary sources will be the secondary sources that are referred to in the factums. So it's unlikely that at large a judge would say, well, I have a patent case, I'll go and read a textbook on patents. That's too generalized. So what will happen is that the factum will come in, and there will be all kinds of authorities, judicial judgments and academic authorities and all that kind of stuff. And each judge has 3 law clerks, and the law clerks will be instructed to research the various authorities, depending upon how interested the judge is in the case. And some judges will require that kind of research to be done in every case. So in that sense, yes, it depends essentially on counsel referring to the sources in the factum, and then the judges will go and research that. And after the case is argued, the writing judge will probably do more research and find other authorities, or perhaps if he or she is dissatisfied with something, doesn't feel that they have a good grasp of the point, we'll go and do some further research afterwards. So that kind of thing will occur.
When counsel are giving their oral arguments, do you prefer counsel to go over their entire argument in a less sort of detailed form in order to give you opportunities to ask questions on every topic, or a more detailed survey of what they think are the most important and dispositive issues on the appeal?
The latter. Look, they've only got an hour. They've probably got a factum of 35 or 40 pages. We don't need them to reread the factum. We don't need them to tell us the facts. They should be highlighting the really important issues. Ian Benny used to say, forget the wind-up, make the pitch. And that means get right to the point the moment you stand up. You can assume that the judges will have read the factum, and so you don't need to go back and give them any background and so forth. Now, each case is different, and it may be that in a technical case, a patent case or something like that, it may be advisable to spend 5 minutes or 10 minutes creating some kind of a complex for the judges to work with. In our court, the parties file what they call a condensed book of the authorities they're just going to cite in the oral argument, so that we don't have to go back and plow through all kinds of volumes of material. At the beginning of those condensed books, many counsel write a summary of their argument, and then they will follow that summary in their oral argument. And that's very effective, because that kind of tells us what they consider to be the most important thing, and is short enough that they can do that in the space needed for space allowed for oral argument. And it's quite good, because it probably by the time they've written that summary, it's very sequential and logical, and usually quite helpful. And it's quite helpful to us to go back to that summary in looking at the whole case. So sure.
I have two questions. One is more general and the other is related to IP. My general question is regarding the split decisions of the court. So if it is a close call, 5-4 decision, is that split before an oral argument, or is it at the time of the argument that the swing
Sorry,
vote goes
I'm just
either
not
way?
quite hearing you.
My question is about the split decisions, the 5-4.
The split decisions, yes.
The 5-4 decisions.
Right.
It may not be very applicable in the IP context. Maybe they're more unanimous. But generally speaking, when there is a swing vote, is that at the time of the oral argument stage, or is it already decided prior to that? And if it is at the oral argument, what can an advocate do in order to to get that swing vote to their side?
I think all I could say is this, that before the oral argument, once the judges have read the factums, they'll form a preliminary view of whether they think the appeal should be allowed or dismissed. So in that sense, it's decided on a tentative basis before. But the judges, except for 15 minutes before the hearing, the judges won't get together and kind of decide the case and then feel that they've publicly committed to a certain position. And even 15 minutes before the oral argument, the judges will be pretty tentative about saying, I think that this is a better argument on this side and so forth. So there will be a view that's developed, but the oral argument is there to either reinforce the view that the judge already has or to displace it. And it can be displaced, but as I said to you in my own case, and I think this is probably true of most of the judges, because of the amount of preparation we have to do in advance, and because we don't have enough time in the oral argument to answer and ask all of the questions we want to ask, we formed probably a firmer view going into court than I would have at the Court of Appeal. I'll be candid with you. When I was counsel as a lawyer, I hated it when I came into court and I could tell right away that the judges had made up their mind. And so in the Court of Appeal, I deliberately didn't try to over-prepare, just because I had been on the other side of that, and I figured, well, I'll read the factums, I'll read them once, and then I'll read them the night before the hearing, but I'm not going to go and really try to lock in and get a very firm position. And I want to give counsel a real opportunity to convince me one way or the other in oral argument. Plus, in the Court of Appeal, you have enough time in answering and asking questions to be able to say to counsel, well, look, at page 17 of your factum, you're saying this, and now in oral argument, you're saying that. And what's, am I missing something or not? And, you can really feel more comfortable when you walk out of court, having a better sense of where of at least that point when you come out of court. So that was my approach in the Court of Appeal, to deliberately not over-prepare. But here, because of the exigencies that I told you about, we have to prepare more, so there's more likelihood that the judges are firmer in their view going in. But it won't matter whether it's a close case or not. I mean, the fact that it's 5-4 or unanimous, they'll form their view independently, and so it won't matter. It's a matter of happenstance as to how it tumbles out.
There actually is an interesting article in the Osgoode Law Journal. I'm not sure whether it was last issue or the couple of issues before, where there's an analysis of judgments in the Supreme Court where the author thinks what looked like a minority judgment or what looked like initially was written as a majority judgment, in fact turns out to be a minority judgment. And and the author speculates as to the reasons why what was seemed to be a majority judgment suddenly collapsed into a minority judgment, and reads quite the way that it does. So I guess it's still having gone in, listened to the argument, it's still, I suppose, possible that after the argument and the judges are still pondering, and a judgment comes round, and suddenly they'll say, "No, I thought I agreed with that, but I almost entirely disagree with everything that was said there. Now that I see it in writing," and that may start a little snowball running.
It's very disheartening to write, thinking you're in the majority, and seeing that your writing has convinced everybody to go to the other side. You said you had I'm sorry, you said
Yes,
you
I
had
had
a
a
more
s-
specific question.
Yes, I do. I was just curious, is there any scope of the use of technology when it comes to oral submissions in front of the Supreme Court of Canada?
Well, they are introducing a lot of technological innovation there. People can file online now. The leave application material that the judges get comes to us online. Right now, it's unfortunate because it's costly, but it's a dual system, a lot of paper and online. But I would suspect that within the next generation of judges, within the next 5 or 10 years, they're probably going to be disposing of a lot of the paper, and it's probably going to be all coming by way of advanced technology. Is that the kind of technology that you were talking about?
I was
or?
more focused on the oral submissions, given the nature of the IP, cases that are coming. They're very technical, especially if you're building, let's say, 5 minutes factual basis of what the case is about. Do you see if there is any a visual aid that could be used by the courts? In that sense, I meant.
Occasionally, we'll have a case with visual aid, occasionally, but it's pretty rare at this point. trying to think of cases where we have had that. I mean, we've had criminal cases where, you know, maps and all that kind of thing may appear, and perhaps it will be on a large screen sometimes. So I can recall that, and I can recall some other case. I think there was a patent case. Whether it was a patent or well, we have had cases where stuff has appeared on screens, and it's been helpful. One of the problems we have with it is that the judges are not have that much facility ourselves, and we've got screens right in front of us, but we may not be able to keep up with counsel. You know, if counsel is referring to stuff that we should be seeing on the screen, it hasn't worked out very well so far. So we still use that paper book, the condensed book that I was telling you about.
You had mentioned that there was a recent change to the procedure of the court where the justices will meet prior to the appeal. This sounds like a recent change, and I'm curious to how this change came about and to what potential inspirations that you look for
Sorry,
change.
and you said it, as to how it came about and?
How the change came about and potential inspirations for future change in the operation of the court.
I can tell you exactly how it came about. Every judge who comes to the court brings something new. And in this particular case, it's Justice Wagner from Quebec who said that in the Quebec Court of Appeal, the judges met in advance, and that he found it helpful to get a sense of where the other judges were before going into court. And so when he said that, the judges said, well, okay, we can try that. So we've done that, but it's just been in the last, I think just in November, if I'm not mistaken. I don't think we were even doing it in October. So it just happens to be that one judge makes a suggestion, and everybody goes along with it, and so that's the way that things occur. I can tell you that one of the things that I brought was the 10-page factum and 10 minutes of argument for interveners. If you read the rules of our court carefully, you might interpret them to say that interveners have 20 pages for their factums. And I remember not being very pleased about that. And one time when I was the duty judge, we call it the rota judge, dealing with motions, and the interveners would come and apply for time to give oral argument and time to file their, or for the right to intervene. I said, why are they given 20 pages? And the lawyer, one of the staff lawyers, said, oh, the rules say that they're given a minimum of 20 pages. And I said, I don't read that as a minimum. And I said, we're going to make it 10 pages. And we made it 10 pages. And I've never looked at the rule too closely, I have to admit. But 10 pages are locked in now, and 10 minutes of oral argument. And you'd be surprised. I do believe that it allows us to hear more interveners, and it causes the interveners to focus better. And so every judge brings something when they come, and the 15-minute before is as a result of Justice Wagner.
Justice, I feel like you've written some stronger dissents, and particularly one comes to mind as ESA. And I was wondering, within that case, on the question of whether or not deciding this issue was a 5-4 split between the courts, and I believe you had written the dissent. Was there any advocacy on your part in terms of maybe trying to get one of the other judges to come over? Because you seemed like you felt really strongly on that point of law there.
I was such a good advocate that I lost the majority. Actually, you know, you're bringing up a fairly sensitive point. In our court, you're not supposed to lobby the other judges. I think that at one time, maybe 10, 20 years ago, I don't know, there were judges in the court that would lobby each other. And I take it that it made some of the judges uncomfortable. And so we have kind of an unwritten rule, if you like, that you don't go and lobby. Well, having said that, if you really feel strongly about a case, you may go to the writing judge, and you may not lobby the writing judge to change his mind on the result, but you may lobby him or I shouldn't say lobby him, but you'll send him a memo and you'll try fairly hard to get him to come along, at least in the writing of his judgment, with some of the ideas that you have. So in that sense, you try to have input in the judgment. I always say that it's better to put a little water in your wine and get the majority judgment to reflect something of what you want to say than to go off in a huff and write a dissent, or worse still, a set of concurring reasons. Because nobody, you know, the dissent and the concurring reasons, you know, they say, well, today's dissent is tomorrow's majority. That's like whistling past the graveyard. You'd rather be in the majority, and so you do. I mean, I'm interpreting your term lobbying very widely when I say this, but you do go to the majority judge and try to get that judge to come along with what the ideas that you want expressed. But when you do that, you've really got to be satisfied that the result is right. And then it's a question of the expression of how it's reached, that you try to get that judge to, and all the judges do that. I mean, the memos are going around the court all the time. Part of the reason that it takes so long to get our judgments out is that memos from 8 other judges are floating around all the time. And sometimes one judge will write a memo and say, I want you to change this. Another judge will say, if you change that, you've lost me. And so, you know, things can take a little unusual courses. But those things are happening all the time. But the individual lobbying, going over and saying, well, I've got 4 judges, will you come with me? And what will I do? I've got nothing to give. So.
You made the comment earlier that the authorities will stand for themselves. And so I'm wondering, how important do you think deference to precedent is at the Supreme Court level, and whether you ever feel like lawyers are trying to bury you in a pile of precedents rather than engaging with the substantive merits of the issue?
I'm going to take your question in 2 parts. The second part is about lawyers burying us in authorities. I say that the best thing that you can do in writing a factum is to cite the 1 or perhaps 2 authorities that stand for the proposition that you are that you're trying to put forward. Sometimes we see factums with 8 authorities, and you send your law clerk to go and research the 8 authorities, and they don't support the position, or they don't all support the position. And it just means that that the lawyer's kind of, I don't know whether he or she is trying to just dump authorities on you and think that that's going to impress you, but that doesn't work. You're best off to not try to bury the judge in authorities. Use the ones that are the most persuasive, and that's all. First part of your question I interpreted to mean, how I'll use the word slavishly, but how slavishly do we follow the precedents, and will we depart from the precedents? Well, as a general rule, our function is to maintain the predictability and certainty of the law. That's the whole idea of stare decisis and adhering to precedent. And we won't lightly depart from a prior precedent. So you can't just waltz into court and say, well, that precedent was wrong. And, but there will be occasions where precedents will not be not be considered as persuasive as new judges who are on the court think should be the case. I'll use one example that I have a very personal interest in, and that's the Harvard mouse and Monsanto. You'll know that in the Harvard mouse, the majority of the court said that the genetically modified mouse was not patentable, even though the genes were patentable. The stuff in the Petri dish was patentable. In Monsanto, the next year, arguably, had they followed the Harvard mouse, they would have said that the rapeseed plant, the canola plant, was not patentable, even though the genetic material was patentable. Well, 2 judges were changed on Monsanto, and they did not follow the Harvard mouse. And so, you know, there will be those kinds of dynamics. Unfortunately, judges will not follow precedent, but they won't say that they're not following precedent. You know, we don't like to say that we're not adhering to stare decisis or following precedent, but sometimes judges will distinguish, and sometimes the distinction will not be a distinction, or it won't be a very strong distinction. So yeah, we try to be intellectually honest about it, and we try to follow the precedent. We have I shouldn't say rules, but there are criteria for deciding when you depart from precedent and when you won't. And the bar is pretty high to actually positively depart. But other cases will come along where judges try to weasel through and depart without saying they're departing. And that's then cannon fodder for the academics who look at us and say, what are you doing?
Well, this looks like I'll take one last question.
So I guess considering that, you know, the general population doesn't have a very good understanding of law in general, and I'd argue that even some lawyers don't necessarily have a very good understanding of law, does it irritate you when a decision that comes from your court might be mischaracterized either in the news or by certain lawyers in other court cases?
Well, the short answer is yes. What irritates me more is when somebody walks in and says, well, in that case you said such and such, and I'm saying to myself, yeah, but I didn't want it to apply to this case. But seriously, yeah, sometimes the press doesn't report the case accurately, and they absolutely miss the point. I think I can give you an example. At least this is my take on the case. A judgment was issued maybe a month or 2 or 3 ago called Rizzulli, involving an individual who was in intensive care at the hospital, and the doctors wanted to withdraw life support, and the family didn't want the life support withdrawn, and the case ended up in court, and it ended up coming to our court, and the question was, how does this get resolved? Well, the whole issue boiled down, and between the majority and the dissent, the whole issue boiled down to whether the decision maker should be the court, or where the family and the hospital are disagreeing, whether the decision maker should be the court or the Consent and Capacity Board in Ontario. That's really what ultimately occurred. Well, the way the press reported it was, family wins. Doctors can't withdraw life support. Well, there's no question the doctors could unilaterally withdraw life support to begin with. But that was I say that was totally mischaracterized by the press, and by more than one press. I mean, this wasn't just one wayward reporter. A number of the press reported, because of course it gains more headlines to say family wins and doctors can't withdraw and so forth. But that really wasn't what the case was about. The case was only about which board, the court or board, decides how this gets done. So sure, it happens, and it's annoying when you see that, and but we live with it.
I wonder whether in cases like that the court might consider a practice of having a press release. I mean, I know that you have it's not a joke, there are courts that do that. That in Fairfax not just have the formal head note that is written by one or more of the clerks as a summary, a legal summary of what the case was about, but one would but also have a separate press release saying, well, this is actually what we're deciding here, and this is not what we're deciding here.
If there's time, I'll just quickly respond to that. In fact, before our judgments come out, we have the chief, we call him the executive legal officer of the Chief Justice, who's a lawyer of some standing, but who is seconded to the court for a few years. Gives a briefing to the press in advance in a lockup, and does exactly what you're saying, David. Walks through the judgment in a neutral way, has to, because sometimes it's not a unanimous judgment, but walks through it, gives a briefing to the press. The problem is that the press, not all the press is there. A lot of the press is in Toronto or out west or wherever, and they're not here. And so they don't get that. And then there's the title writers. The title writers are not the reporters. And so the people who write the headlines are trying to sell newspapers or whatever. And so things happen. So we make an effort to try to do that in advance. I don't think that we would ever have a press release afterwards saying you got it wrong. But I think in advance, but we do it in advance. And,
I think it's certainly in sensitive cases. I know in the Supreme Court, the Appellate Division of the Supreme Court of South Africa does that. I see a press release saying in plain language that reporters can pick up and use this is what it's, especially for the ones that ain't there. When an oral briefing occurs, it sometimes helps. I don't know, but well, maybe this is something you can bring to the court, I think, as your new contribution. Well, I want to wrap up, and I think, in a way, what you've seen here is an example of the substance of the talk. That is, you've seen appellate court advocacy given in its best form by the person who has presented the lecture today. I think that you'll notice the way in which the judge gave his talk, and it may be when you go back and analyse it, you will see the elements of what constitutes effective advocacy right there. I want to say on behalf of all of you, thank you very much, Justice Rothstein, for coming and sharing those thoughts with us and in your frank responses to the questions delivered. Thank you very much.
Thank you.